Good evening for those of you here in the audience. Good morning, good afternoon for those watching us from elsewhere, or I'm sure rewatching with great enjoyment in the future. I'm Martin Paperinskis. I'm reader in public international law here at UCL Laws, and tonight I'm here in the capacity of the co-convener of Current Legal Problems lecture series. I usually say in the introduction that the role of the co-convener is a modest, but not an irrelevant one. And I have to make 3 points in that capacity. First, remind you of current legal problems. CLP is University College London flagship lecture series taking place every year since mid-1940s and even through the pandemic. And I'm very, very pleased to welcome you back to the first blended version of Current Legal Problems and to open this academic year. CLP hosts the inaugural lectures of our professorial colleagues as well as outstanding star academic speakers not from UCL. So that was the first point, and at the end of the year you'll have the opportunity to read all the lectures, including tonight's, in Oxford University Press's Current Legal Problems yearbook, earlier advance access. The second point that I want to make relates to structure, and as you will see, CLP is in that sense a slightly peculiar animal. There are three people on the stage. I'm the host. I will introduce the chair in a minute, and that will be the third point that I will make. The chair will then introduce the speaker. The speaker will deliver the lecture, and after the lecture, you will have a chance to ask questions in a blended manner. One hopes that it works perfectly. Those in the audience will be able to ask questions by indicating in a customary manner their willingness to do so and remove mask while they're asking the question. You will not be provided with a microphone, so the chair will repeat the question for the purposes of recording. Those who are online will be able to ask your questions through the Mentimeter system that you have been provided with. The third point is perhaps the most pleasing one, and that is introduction of the chair. Customarily, we choose our chairs from leading figures from legal practice, although I think that tonight's speaker and chair show the complexity of drawing the sharp line between academia and practice, because plainly they excel in both. Elizabeth Wilmshurst is Distinguished Fellow International at Chatham House. She was a legal advisor in the United Kingdom Diplomatic Service until 2003. Between 1994 and 1997, she was the legal advisor to the UK mission to the United Nations in New York. She took part in the negotiations for the establishment of the International Criminal Court, and thereafter in the preparatory commission establishing the court. After she left the Foreign Office, she taught part of the International Criminal Law Masters module here at UCL. Noting that there wasn't a satisfactory international criminal law text at that time, she determined to get one written and put together the four who wrote Introduction to International Criminal Law and Procedure with Cambridge University Press. She took part in the writing of the first three editions. The book is frequently known as Cryer et al., and we all mourn his recent passing away. Madam Chair, the floor is yours.
Thank you so much, Martins, and thank you to University College. What a pleasure it is to be here in person at UCL again. So welcome to you here, and welcome to all of those online. It's a very great pleasure to be introducing our speaker, Professor Payam Akhavan. I've just picked out just a very few matters to mention from his extremely distinguished record. He's Senior Fellow of Massey College, University of Toronto. He's a Special Advisor on Genocide to the Prosecutor's Office of the International Criminal Court and Senior Advisor to Canada's Global Affairs Ministry. He served as the first legal advisor to the Prosecutor of the International Criminal Tribunal for the former Yugoslavia, And he's written extensively on international criminal law. I'm sure we've all benefited from his articles and other writings. He's appeared as counsel before the International Court of Justice, the European Court of Human Rights, and the Supreme Court of Canada. And he's part of the legal team representing the Gambia in the case against the Myanmar before the ICJ. So, the perils of progressive jurisprudence, Nullum Crimen in particular. Payam, over to you.
Thank you. Thank you very much, Professor Wilmshurst, for that kind introduction, and Professor Paperinskis and the distinguished UCL faculty for giving me the honor of delivering this lecture. In view of those very kind and generous comments you made, I'm tempted to make some self-deprecating remarks, but my brother would remind me not to be humble because I'm not that great. But thank you very much nonetheless for that very warm introduction. These are truly scenes from hell, written on the darkest pages of human history. Those were the words of Judge Fouad Riyad. The date was November 16th, 1995. The occasion, the confirmation hearing for the indictment against Radovan Karadzic and Ratko Mladic following the mass murder of some 8,000 Bosnian Muslims in Srebrenica. There was a sense of despair that the newly established ICTY had failed to deter this genocide. But there was also a sense of promise in that expression of opprobrium by the first ever UN Criminal Tribunal. Prosecuting Karadzic and Mladic was still a flight of fantasy, but after a half-century hiatus, the resumption of the Nuremberg project provided a unique opportunity for the progressive development of international criminal law. The only thing missing was a defendant who appeared on April 24th, 1995, in the person of Duško Tadic. Despite his lowly status in the hierarchy of perpetrators, his arrival was met with exuberance. He wasn't among the arch-villains of ethnic cleansing, but having him in The Hague was preferable to prosecuting a cardboard effigy of powerful leaders, as some had quipped. In the months that followed, this small fish would be transformed into a giant sea serpent in the imagination of jurists, his name associated with one of the most notable precedent-setting judgments of contemporary times. Like human rights and humanitarian law, international criminal law excites our passions. Crimes against humanity, genocide, aggression. In the shadow of the Second World War, these new offenses represented a fundamental shift from a state-centric to a human-centric international law, a merging of law and morality, a blurring of the once sacrosanct boundaries between lex lata and lex ferenda. The jus cogens, obligations erga omnes, indeed the very idea of justice, became inextricably interwoven with these global grundnorms that rebuked the excesses of modern amoral positivism. In its 1951 advisory opinion on reservations to the Genocide Convention, the ICJ captured this transcendent conception of normativity. The dilution of state consent as the fountain of law was captured in its dictum that the principles underlying the convention, which had only been adopted by the General Assembly 3 years earlier in 1948, were already recognized by civilized nations as binding on states even without any conventional obligation. In respect of interpretation, the court stressed the treaty's purely humanitarian and civilizing purpose and its object to confirm the most elementary principles of morality. The contracting states, it noted, do not have any individual advantages or disadvantages, nor interests of their own, but merely a common interest. It is now an article of faith that such norms should be interpreted expansively. Cosmopolitan jurists would celebrate this teleological sensibility as progressive jurisprudence, a step forward in the ongoing humanization of international law. There is, however, a notable divergence between the interpretation of human rights and humanitarian law on the one hand, and international criminal law on the other. This arises from the Nullum Crimen Sine Lege principle enshrined in Article 15 of the ICCPR among the non-derogable human rights. Article 22 of the ICC Statute contains an even more exacting standard. It prohibits not only the retroactive application of crimes, but also expansive interpretations and extensions by analogy. Even ambiguities are to be resolved in favor of the defendant. The ICC pretrial chamber in Lubanga explained that the 4 pillars of the principle of legality are based on written lex scripta, pre-existing criminal norms approved by the states parties to the Rome Statute, lex previa, defining prohibited conduct and setting out the related sentence, lex certa, which cannot be interpreted by analogy in malum partem, lex stricta. It is a matter of curiosity that despite its fundamental character, the principle of legality has been given curt treatment, if not outright ignored, in the evolution of international criminal law. The pattern of privileging substantive justice over the strictures of positive law can be traced to the foundational Nuremberg moment. This applied in particular to the 2 normative pillars of the 1945 Charter of the International Military Tribunal, namely crimes against peace and crimes against humanity, in Article 6, paragraphs A and C, respectively. Unlike war crimes in paragraph B, these were novel offenses without a firm footing in either treaty or customary law. In respect of crimes against peace, the defendants submitted a trial that ex post facto punishment is abhorrent to the law of all civilized nations, that no sovereign power had made aggressive war a crime at the time that the alleged criminal acts were committed, that no statute had defined aggressive war, that no penalty had been fixed for its commission, and no court had been created to try and punish offenders. The tribunal gave short shrift to this argument. The maxim nullum crimen sine lege, it held, is in general a principle of justice, to assert that it is unjust to punish those who in defiance of treaties and assurances have attacked neighboring states without warning is obviously untrue. For in such circumstances, the attacker must know that he is doing wrong, and so far from it being unjust to punish him, it would be unjust if his wrong were allowed to go unpunished. The tribunal invoked the 1928 General Treaty for Renunciation of War as an instrument of national policy, the so-called Kellogg-Briand Pact, to which Germany and Japan were among the original signatories. But it did so only to reinforce its view that criminalization of aggression was a matter of substantive justice. The legal pedigree of crimes against humanity was even more precarious. It was derived from a vague reference to the laws of humanity in the preamble to the 1899 Hague Convention II respecting the laws and customs of war on land, revised as the Hague Convention IV at the Second Peace Conference in 1907. Following the First World War, this so-called Martin's Clause, named after the Russian jurist Fyodor de Martins, had become a matter of interest. The report of the Commission on the Responsibility of the Authors of the War and on Enforcement of Penalties, submitted to the 1919 Preliminary Peace Conference in Paris, recommended that in addition to the laws and customs of war, enemy nationals who have been guilty of offenses against the laws of humanity should also be liable to prosecution. This was particularly relevant to atrocities against the Armenians of Ottoman Turkey that, because they were not nationals of an opposing belligerent, did not qualify as violations of the laws and customs of war. But there was dissent on this point. A memorandum of reservations submitted by the United States representatives noted that moral offenses, however iniquitous and infamous and however terrible in their results, were beyond the reach of judicial procedure. It stressed that a judicial tribunal only administers existing law, leaving to another forum infractions of the moral law and actions contrary to the laws and principles of humanity. It registered a further objection that the laws and principles of humanity are not certain, varying with time, place, and circumstance, and according, it may be, to the conscience of the individual judge. There is no fixed and universal standard of humanity. The laws of humanity surfaced once again in the Nuremberg Charter to address atrocities that did not qualify as war crimes because of the victim's nationality, in particular, the Jewish populations of the Axis powers. In contrast to the American dissent in 1919, the distinction between legal and moral offenses was abruptly abandoned by the United States Military Tribunal at Nuremberg. The 1947 justice trial held that whether the crime against humanity is the product of statute or of common international law, or as we believe of both, we find no injustice to persons tried for such crimes. They are chargeable with knowledge that such acts were wrong and were punishable when committed. It stated that the ex post facto rule cannot apply in the international field as it does under constitutional mandate in the domestic field. International law is not the product of statute for the simple reason that there is as yet no world authority empowered to enact statutes of universal application. It concluded that to have applied the principle of legality to judicial decisions of common international law would have been to strangle that law at birth. The 1948 judgment in the Einsatzgruppen trial was even more blunt, simply noting that no one can claim with the slightest pretense at reasoning that there is any taint of ex post factoism in the law of murder. This contempt for pedantic positivism culminated in the judgment of the Jerusalem District Court in the 1961 Eichmann trial. It is not necessary, the court observed, to recapitulate in Jerusalem 15 years after Nuremberg the grounds for the legal rule on the crime against humanity. For these terms are written in blood, in the torrents of the blood of the Jewish people which was shed. That law was born in the crematoria, and woe to him who will try to stifle it. Following the ILC codification of the Nuremberg principles in 1950, concern about their consistency with the principle of legality persisted. This was reflected in the drafting of the Human Rights Covenants from 1948 onwards. Upon its adoption in 1966, Article 15, paragraph 1 of the ICCPR provided that no one shall be held guilty of any criminal offense on account of any act or omission which did not constitute a criminal offense under national or international law at the time when it was committed. Although general principles are clearly also part of international law, the drafters saw fit to include a separate Article 15, paragraph 2, expressly stipulating that nothing in this article shall prejudice the trial and punishment of any person for any act or omission which at the time when it was committed was criminal according to the general principles of law recognized by the community of nations. Despite the concern that no court should be allowed to convict an individual by applying vague general principles, the travaux préparatoires of the Covenant indicate that this provision was retained to eliminate any doubts regarding the legality of the judgment rendered by the Nuremberg and the Tokyo tribunals, to confirm and strengthen those principles, and to ensure that if in the future crimes should be perpetrated similar to those punished at Nuremberg, they would be punished in accordance with the same principles. Given the constraints of treaty and custom, general principles became the source of last resort to confer ex post facto legitimacy on the law. By the time Security Council Resolution 827 established the ICTY on May 25, 1993, the problem of retroactivity had been significantly diminished. The Nuremberg principles had become firmly entrenched and supplemented by new conventional and customary law. Resolution 808 of February 22, 1993 had requested the UN Secretary General to produce a report addressing inter alia the question of the ad hoc tribunal's jurisdiction ratione materiae. It noted that the application of the principle nullum crimen sine lege requires that the International Tribunal should apply rules of international humanitarian law, which are beyond any doubt part of customary law, so that the problem of adherence of some but not all states to specific conventions does not arise. There was no explanation as to why either treaty law or general principles would not equally satisfy the principle of legality. ICTY jurisprudence would subsequently expand subject matter jurisdiction based on violations of agreements binding upon the parties to the conflict considered qua treaty law, in particular agreements which have not turned into customary international law. General principles, by contrast, would be invoked primarily in respect of individual criminal liability. The Secretary General's report was a seminal post-Nuremberg codification exercise. It concluded that the part of conventional international humanitarian law, which has beyond doubt become part of international customary law, is the law applicable in armed conflict as embodied in the Geneva Conventions of 1949, the 1907 Hague Convention in respect of laws and customs of war on land, the Convention on the Prevention and Punishment of the Crime of Genocide of 1948, and the Charter of the International Military Tribunal of 1945. Despite this scrupulous adherence to the principle of legality, Article 3 of the ICTY Statute was drafted as a general clause covering all humanitarian law violations. It was illustrative rather than exhaustive, providing that violations of the laws or customs of war shall include but not be limited to certain enumerated acts. This turned out to be a crucial loophole, and the tribunal squeezed the jus cogens out of it to expand its subject matter jurisdiction. The landmark October 2nd, 1995 Tadic decision on the defense motion for interlocutory appeal on jurisdiction became a symbol of this so-called Grotian moment. I'm not sure if it's Grotian or Grotian, so forgive me if I've put the emphasis on the wrong syllable. It was a long-awaited opportunity for the elaboration of humanitarian law beyond the Nuremberg principles. Gradual crystallization gave way to swift chrysalis as progressive jurists, notably the distinguished ICTY president Antonio Cassese, gave life to this dormant body of norms with unbridled enthusiasm. One of the grounds of appeal was the claim that the ICTY lacked subject matter jurisdiction over war crimes committed in internal armed conflict, namely violations of Common Article 3 of the Geneva Conventions, incorporated in the indictment pursuant to the general clause in Article 3 of the statute. The appeals chamber recognized the paucity of authoritative judicial pronouncements and legal literature on the existence of customary international rules governing internal strife, and also whether they entail individual criminal responsibility. Nonetheless, it made sweeping assertions about the applicable customary law without much methodological rigor. One example was its dictum that elementary considerations of humanity and common sense make it preposterous that the use by states of weapons prohibited in armed conflicts between themselves be allowed when states try to put down rebellion by their own nationals on their own territory. What is inhumane and consequently proscribed in international wars cannot but be inhumane and inadmissible in civil strife. Elsewhere, it similarly held that principles and rules of humanitarian law reflect elementary considerations of humanity, widely recognized as the mandatory minimum for conduct in armed conflicts of any kind. No one can doubt the gravity of the acts at issue, nor the interests of the international community in the prohibition. The content of such elementary considerations of humanity and its relation to customary law was not entirely clear. In Corfu Channel in 1949, the ICJ referred to this as a source of state obligations based not on the 1907 Hague Convention 8 on submarine mines, but general and well-recognized principles even more exacting in peace than in war. Given the context of armed conflict, however, the ICTY Appeals Chamber was presumably invoking the Martens Clause. The views of Judge Cassese, who was presiding in Tadic, shed some light on this question. True to his scholarly credentials and continental civil law tradition, he was precise and positivist in his approach. In his dissenting opinion in Erdemovich, he had reproached the judicial pragmatism of common law judges, emphasizing that a policy-oriented approach in the area of criminal law runs contrary to the fundamental customary principle Nullum, Crimen, Sine, Lege. In respect of the Martens Clause, he had noted in an academic publication, which is called the Martens Clause, Half a Loaf or Simply a Pie in the Sky, a very characteristic Cassese-esque title from the 2000 European Journal of International Law. He referred to the Martens Clause as ambiguous and evasive, arguing that it lends itself to many and conflicting interpretations. He dismissed it as lip service to humanitarian demands and did not consider it as a source of law in addition to the treaty and custom processes. His conclusion, however, betrayed the strategic deployment of this very same ambiguous and evasive device for progressive development of the law. What counts, he wrote, is not so much how these advances, meaning to say the progressive development of humanitarian law, are made, but rather that they be made, lest this body of law remain encumbered by the numerous fetters imposed by the traditional respect for state sovereignty. The Tadic window of opportunity was exploited also by way of obiter dicta, for instance, to eliminate the nexus with war requirement in Article 6c of the Nuremberg Charter. The Appeals Chamber noted that it is by now a settled rule of customary international law that crimes against humanity do not require a connection to international armed conflict. Indeed, as the prosecutor points out, customary international law may not require a connection between crimes against humanity and any conflict at all. This precedent shaped the new peacetime definition of crimes against humanity in Article 7 of the ICC Statute, which you would have been busy negotiating at the time, with significant consequences on the scope of international criminal law. Such judicial activism was by no means limited to the ICTY's early foundational jurisprudence. It persisted in later cases, and only rarely would judges question expansive interpretations of the law. A notable instance is the separate and partially dissenting opinion of Judge Wolfgang Schomburg in Gallich. At trial, there had been a conviction for the crime of attacks on civilians for the campaign of shelling and sniping against the civilian population of Sarajevo. This was based on the general clause in Article 3 of the statute, pursuant to which Articles 51.2 and 13.2 respectively of Additional Protocols 1 and 2 of 1977 were incorporated. The ground of appeal related to the further conviction of Gallich on the same facts for the separate crime of acts and threats of violence, the primary purpose of which is to spread terror among the civilian population. This corresponded to the second sentence of the same provisions of the additional protocols. In the Appeals Chamber judgment of November 30th, 2006, Judge Schomburg did not agree with the majority's affirmation of the conviction for the crime of inflicting terror upon civilians. In his view, it was not beyond doubt part of customary law at the time of the conduct between 1992 and 94. In arriving at this conclusion, he referred notably to the requirement of extensive and virtually uniform state practice set out by the ICJ in North Sea continental shelf, a strict test that jurists may embrace with greater enthusiasm in the context of maritime delimitation than humanitarian law. In support of its finding, the Appeals Chamber majority had pointed inter alia to a continuing trend of nations criminalizing terror as a method of warfare. Judge Schomburg stressed that one cannot conscientiously base a conviction in criminal matters on this basis. A mere trend, he noted, in fact indicates that this development had not yet amounted to undisputed state practice. He pointed out that the International Tribunal is required to adhere strictly to the principle of nullum crimen sine lege previa. It would be detrimental, he held, if our jurisprudence gave the appearance of inventing crimes, thus highly politicizing its function, where the conduct in question was not without any doubt penalized at the time when it took place. Despite such occasional misgivings, the prevailing sentiment was that half a century after Nuremberg, the need for evolutionary adaptation of norms outweighed strict application of the principle of legality. It is noted that the principle of legality does not necessarily exclude such evolutionary adaptation. In SW versus United Kingdom, for example, the European Court of Human Rights held in respect of a new common law precedent criminalizing marital rape that I'm sure many of you will be familiar with. It held that the progressive development of the criminal law through judicial lawmaking is a well-entrenched and necessary part of legal tradition. The principle of legality cannot be read as outlawing the gradual clarification of the rules of criminal liability through judicial interpretation from case to case, provided that the resultant development is consistent with the essence of the offense and could reasonably be foreseen. But there comes a point at which such judicial interpretation becomes unmoored from the boundaries of legal reasoning. In this regard, the celebrated Akayesu judgment of 1998, the first genocide trial before the ICTR, is instructive. At issue in this landmark case was whether the Tutsi minority were a national, ethnical, racial, or religious group, these being the exhaustively enumerated groups protected by the 1948 Genocide Convention. In describing the historical context, the trial judgment addressed the dubious Hutu-Tutsi dichotomy underlying the 1994 extermination campaign. Prior to and during colonial rule, it noted, Rwanda was a complex and advanced monarchy that ruled the country through the Tutsi nobility. The Hutu-Tutsi distinction was based on lineage rather than ethnicity. Indeed, the demarcation line was blurred. One could move from one status to another as one became rich or poor or even through marriage. Under colonial rule, the domination of the Tutsi ruling class was attributed to their racial superiority based on the misguided racist theories of the time. By the 1930s, the Belgian authorities introduced a permanent distinction by dividing the population into groups which they called ethnic groups. It became mandatory for every Rwandan to carry an identity card mentioning his or her ethnicity. In determining whether the Tutsi qualified as a protected group, the trial chamber noted that the term ethnic group is in general used to refer to a group whose members speak the same language and or have the same culture. Therefore, one can hardly talk of ethnic groups as regards Hutu and Tutsi, given that they share the same language and culture. Akayesu had a simple solution for this dilemma. It simply expanded the four protected groups by analogy, so it would apply to the Tutsi. It reasoned that they all share the common characteristic of stability and permanence, as distinct from the more mobile groups which one joins through individual voluntary commitment, such as political and economic groups. It claimed, without any specific reference to the travaux préparatoires, that the intention of the drafters of the Genocide Convention was to ensure protection of any stable or permanent group. Thus, Akayesu's conviction for genocide was on the grounds that the Tutsi did indeed constitute a stable and permanent group and were identified as such by all. The Nullum Crimen Sine Lege principle did not figure in this judicial creativity. Apparently, given the monstrous scale of the 1994 massacres, respecting the boundaries of positive law was not a priority. By 1998, the Rome Diplomatic Conference had replaced the minimalist ICTY and ICTR statutes with an extensive codification in the ICC Statute. There were far fewer lacunae that required clarification. There were no general clauses, though some illustrative provisions remained. For instance, Article 7K includes, in addition to the enumerated acts of crimes against humanity, other inhumane acts of a similar character, intentionally causing great suffering or serious injury to body or to mental or physical health, seemingly an extension by analogy. But on the whole, the drafters adopted a strict definition of the applicable law in Article 21, an apparent constraint on the sort of judicial activism that prevailed in the ad hoc tribunals. It sets out a hierarchy of sources, beginning first with the statute elements of crimes and the rules of procedure and evidence. Second, applicable treaties and the principles and rules of international law. And failing that, general principles of law derived by the court from national laws of legal systems of the world. The al-Bashir pretrial chamber noted that the secondary sources can only be resorted to where there is a lacuna in the written law contained in the statute elements of crime and rules, and such lacuna cannot be filled by application of the criteria of interpretation provided in Articles 31 and 32 of the Vienna Convention on the Law of Treaties and Article 21.3 of the statute. This, however, has not seemingly deterred judges from resorting to expansive interpretations. A recent example is the Entaganda appeals judgment of March 30th, 2021. At issue was whether in the context of internal armed conflict, certain acts such as the pillaging of objects at Mongwalu Hospital in Ituri province in the Democratic Republic of Congo fell within the definition of attacks against protected objects as a war crime under Article 8(2)(e) Roman 4 of the ICC Statute. The trial judgment held as follows. The Chamber notes that neither the statute nor the elements of crimes include a definition of the term attack. Having regard to the established framework of international law, the Chamber notes that the crime of attacking a civilian population is based on Article 13(2) of Additional Protocol 2. This protocol does not define attacks, but Additional Protocol 1 does, and the term is considered to have the same meaning. Attack must therefore be understood within the meaning of Article 49 of Additional Protocol 1 as acts of violence against the adversary, whether in offense or defense. It found on this basis that the pillage and other acts not committed during the actual conduct of hostilities did not qualify as attacking protected objects, even if they may qualify as other war crimes under Article 8. On appeal, Judge Eboe Osuji, together with Judge Ibanez Carranza and Judge Balungi Bosa, disagreed with the trial judgment. His partly concurring opinion expressed preference for the ordinary dictionary definition of attack unencumbered by a nexus with hostilities as required by the additional protocols. He maintained further that there should be no distinction between the definition of an unlawful attack as a war crime under Article 8 and the much broader term attack directed against any civilian population in the chapeau of crimes against humanity, even if Article 7 applies in both peacetime and war and in respect of state or organizational policy. In support of this interpretation, he invoked the ubiquitous, you guessed it, Martin's Clause, which he referred to as the old great gap filler. There is a prevalent sentiment that ICC jurisprudence should avoid an impunity gap insofar as the Rome Statute's object and purpose is to put an end to impunity for international crimes. It is a rather circular reasoning, since international crimes must first be defined, and their arbitrary expansion is inconsistent with the principle of legality. It is one thing to address lacuna, and yet another to invent them as an opportunity to push legal boundaries. There comes a point where the humanitarian loophole becomes a black hole into which all legal reasoning disappears. What do these examples tell us about the character of international criminal law jurisprudence? The Nullum Crimen Sine Lege principle is a limitation on arbitrary power, but we are not wont to see fragile courts in the same light as totalitarian states. Instead of a menacing leviathan lurking beneath the sea, we see a vulnerable minnow fighting for survival against vicious predators in the food chain of global politics. Given the conspicuous shortcomings of the international legal order, we do not view judicial activism in a suspect light, especially in defense of common humanitarian interests. The cautious judge respecting positive law is not the heroic figure that we seek in the narrative of progress. There is no glory in strict interpretation. But this sensibility comes at a cost. We are no longer in the formative phase of Nuremberg and the ICTY when new frontiers had to be charted. We are now in a period of consolidation. The challenge is the normal functioning of the ICC, not groundbreaking jurisprudence. Plodding through mountains of evidence in meticulous detail to determine guilt or innocence based on settled jurisprudence may not be as glamorous as a widely cited opinion on a new point of law. But at this stage, institutional credibility requires predictability, not interpretive adventurism. The temptations of judicial virtue signaling are strong, but they should be resisted in favor of the integrity both of the law and the legal process. One of the perils of humanitarian expansionism is that the inflation of norms may also undermine the purposes of punishment. In respect of utilitarian theories, which one cannot ignore here in Bentham House, the expansion of crimes results in the distortion of incentives in the cost-benefit calculus of deterrence. In respect of retributive theories, furthermore, moral blameworthiness must be commensurate with different types of wrongdoing. Both of these theories are predicated on the stratification of stigma and graduation of sentencing. This can scarcely be reconciled with the blending of distinct offenses into an amorphous humanitarian whole. This is equally true for the expressive function of law. The socio-pedagogical meanings conveyed by criminal justice depend on the fair labeling of prohibited conduct. There are greater and lesser evils, or simply different types of wrongdoing, and not everything that is worthy of opprobrium qualifies as an international crime. In fact, this exceptionalism is integral to the core crimes in the ICC Statute, distinguished from ordinary domestic offenses on account of their special scale and gravity. Their dilution ultimately leads to their trivialization. It should also be considered that outside of the lecture circuit, conceptual abstractions are likely to be far less significant than factual narratives. Survivors of atrocities are less excited by interpretive prowess than we might be in academic circles. The cathartic effect of transitional justice attaining healing and reconciliation flows from reconstitution of communal bonds, not a decontextualized taxonomy of evil. The expressive function is best appreciated through an empathic epistemology, the restoration of social relations rather than distant intellectualization. In this light, it appears misplaced to privilege progressive jurisprudence over victim testimony as the centerpiece of the legal process. This brings me to Judge Riyad's exclamation at the Srebrenica confirmation hearing in 1995, with which I began this speech. "These are truly scenes from hell," he said, "written on the darkest pages of human history." The evidence tendered by the prosecutor, he remarked, describes scenes of unimaginable savagery. Thousands of men executed and buried in mass graves, hundreds of men buried alive, men and women mutilated and slaughtered, children killed before their mothers' eyes. Sophisticated jurists, too, are moved by visceral pain. They, too, grapple with the boundaries of reason and emotion as they struggle to do their job. The voice of survivors carries us from the Hague bubble to the horrid trenches of human suffering, a world away from our penchant for cutting-edge theories and clever twists of phrase. We are reminded that behind every victim there is a name, a father and mother, a brother and sister, a universe of relations forever destroyed. Consider the mothers of Srebrenica, like Nura Mustafic, who stood outside the ICTY courtroom on November 22, 2017, 22 years after that fateful confirmation hearing with Judge Riyad, wiping her tears as the trial chamber sentenced Ratko Mladic to life imprisonment. She has still not found the remains of her son, Aliyah. She holds on to the hope that one day he will show up at her door so she can embrace him once more. Yet others have to be content with a memento of their children discovered in the mass graves, a pair of glasses, a watch, a toothbrush, or a trinket. These are glimpses of the reality behind the legal concepts that we dissect and analyze. They teach us both the potential and the limitations of the law, the imperative necessity, yet gross inadequacy of justice for radical evil. It calls to mind Hannah Arendt's lament that the Nazi crimes explode the limits of the law. For these crimes, no punishment is severe enough. This guilt, in contrast to all criminal guilt, oversteps and shatters any and all legal systems. In this context, humanitarian sentiments may call for modesty and restraint, a humble view of the judicial function, mindful of what it means to reduce the enormity of genocide to the confines of legal process. Respect for the principle of legality may not be fashionable. A good faith attempt at consistent application of positive law may not seem heroic. But at this juncture in the evolution of international criminal law, it may be a better measure of progress than the occasional spectacle. Thank you very much.
Thank you so much, Payam, and thank you for reminding us of the real reality, the horrible reality behind the legal concepts that we're discussing. I've got one question from the online audience, which I will read out while our audience in person think of their questions. You were referring to judicial activism in developing crimes against humanity, but how real can that be when we consider that the rules of determining customary international law are themselves often contested and unclear? And can I put that together with a question from me? What do you think of the argument that in relation to international criminal law, the principle of legality, including Nullum Crimen, has to be applied rather more loosely than in domestic law? I think that was said in the Delitzsch, well, one of the chambers in the Delitzsch case in ICTY. Necessarily, because in domestic law, we think, well, the principle of fair notice, everyone's presumed to know the law, it's unfair to charge someone with a crime which was not a crime when they committed it. But how can we presume knowledge in international criminal law, quite leaving aside the looseness of the wording, which perhaps is not so applicable now that we have the ICC? Somewhere groping in customary international law, is a perpetrator ever to be presumed to know what the law is? Mm-hmm. If you could take those
yes.
That
well, these are very good questions, and I think I alluded to some of them, especially in the comments of the justice trial in 1947, which was still the so-called frontier days of international criminal law, when the question wasn't really gap-filling, but actually formulating basic crimes which formed the subject matter jurisdiction of the tribunal. And it's very clear that customary law, treaty law, and general principles even can satisfy the principle of legality, and no one doubts that domestic legal systems have far greater precision because of the legislative process, the volume of judicial interpretation than international criminal law does. But getting back to the question of the sort of fluidity or indeterminacy of customary law, if we believe that what Article 22 of the ICC Statute says is a worthy principle, well, then we have to resolve ambiguities in favor of the defendant, in dubio pro reo, no expansive interpretations, and in case of doubt, resolve the ambiguity not in favor of the prosecution, but in favor of the defendant. So do we really believe in that? And if we don't believe it, why do we have Article 22 in the ICC Statute? Let's be honest and scrap it and say we don't really think the principle of legality counts for much. We sort of want to pay lip service to it because it's a nice idea. But I want to just conclude by saying that I do recognize that in the earlier formative periods, judicial activism may have been far more necessary than it is now. But at this point in the historical evolution of international criminal law, I think the penchant for writing that 300-page separate opinion and stretching the law in all sorts of ways is actually undermining the credibility of international criminal justice.
Thank you. Any questions from here? Otherwise, there's another one online. Yes, please.
So my question is about the scope of the principle of legality in your view, in particular the ICC. And what I'm curious about is whether you think Security Council referrals of situations involving non-state parties or even ad hoc declarations by non-state parties that accept the jurisdiction of the court would constitute a violation of the principle, seeing as the Rome Statute wasn't previously applicable in that context.
It's a very good question, and of course the Rome's...
Yes,
oh, I'm sorry, yes.
I'm sorry. The principle of Nullum Crimen, what does it, or legality, what does it really mean in practice, particularly with regard to referrals by the Security Council? And I'm going to wrap that up with another question online, which is actually slightly different, but you mentioned the need for fair labelling, and what's the relationship between fair labelling and legality? Sorry, that's a separate question, but you can have them both.
Both very good questions, which I cannot do justice to, but by way of just a very brief response. Well, in terms of temporal jurisdiction, the ICC statute does not apply retroactively. But the question would be, what if a state is not party to the ICC statute, and then there is a Security Council referral? I think the question is, which aspects of the subject matter jurisdiction of the court are not beyond doubt part of customary law or otherwise punishable by general principles? And it would be an interesting discussion. One could say, well, maybe some aspects of the definition of crimes against humanity, some specific prohibited acts. But on the whole, by 1998, I think we'd reached a stage where the overwhelming substance of the subject matter jurisdiction was a matter of customary law prohibitions. And in terms of fair labeling, it's a very good question. But the principle of legality, of course, applies in the criminal law context because of punishment. I know in Canadian constitutional law, it's a principle of fundamental justice because of two dimensions of criminal punishment. One is stigma, and the other is sentencing or imprisonment. And it's often overlooked that stigma itself is seen as one of the aspects of punishment. So in that context, well, fair labeling matters, whether you are convicted of murder as opposed to rape, as opposed to torture, as opposed to deportation. Each of those have a different stigma in respect of the person who's convicted. And as I explained in terms of the expressive function of the law as well, that labeling is part of the socio-pedagogical, if you like, propaganda of the criminal justice process in instilling inhibitions against crime.
Thank you. Yes.
Thank you, and thank you for that lecture, Payam. I wonder if you have any views on whether there's a distinction that could be drawn between expansive interpretation of what kind of conduct can constitute a crime and expansive interpretation of what might be seen as more technical things, such as, for instance, the court's subject matter or temporal jurisdiction or questions of immunities, and whether the principle of legality, whether it's important that it applies equally to both of those or whether it's more important just for subject matter.
So the question is essentially, does Nullum Crimen apply just to the substance of the crime or to the other technical matters in the statute of the ICC, for example, immunity? While you're thinking about that, there's a question over here.
Thanks. I just wondered if you could come back to this fair labelling point, because I think we all follow the reasoning around fair labelling, but one might wonder whether there is a meaningful distinction of stigma given the technicality of some of the manoeuvres you're talking about, particularly as you drive home the point that law struggles to contain the magnitude of all this anyway. I just wondered, is there a bit of a tension between the point about fair labelling inability of law to grasp the reality that matters to people anyway.
And the questioner asked for further clarification on the principle of fair labelling.
Well, maybe I'll begin with your question and then go to yours. I mean, just to be clear, was not intended to have a very specific theory, but more a reflection on the boundaries of reason and emotion because of the reality which international criminal law conveys. And if we go back to the formative Nuremberg moment and arguably also the residual foundational moment of the ICTY, which resumed that project, one could perhaps discount the principle of legality in the name of these all sort of imperative humanitarian norms and objectives, and I did point to that. But I don't think we're there now. And there is the dilution of those crimes does not contribute to the objective of the criminal justice process. So fair labeling has different dimensions. One is the stratification of stigma. Some crimes are more serious than others. If everything becomes torture, if everything becomes murder, if everything, whatever the case may be, then this inflation of norms renders those very serious crimes, it trivializes them. But in addition to that, we need a certain degree of precision, because if we are labeling crimes differently in order to convey different messages to society at large, then blurring them into an amorphous whole doesn't really contribute to the objectives of punishment. And that's especially important because we're dealing here with mass crimes in societies with inverted morality. This isn't sort of instilling habitual lawfulness in a society where someone commits a murder and murder is a deviation from a norm. We're dealing with mass murder, we're dealing with genocide. So that socio-pedagogical expressive function is far more important, I would say, in the context of international criminal tribunals, which makes it that much more compelling to respect fair labeling. And getting back to your question, I'm not sure if I understood it clearly, but the principle of legality applies in particular to crimes, to the definition of crimes, and to the principles of liability. It would not necessarily apply, for example, to state cooperation or questions of immunity, which are procedural and not substantive. And I'm not sure if that's the question that you were asking, but I would say that the principle of legality only applies to the definition of crimes and arguably also to principles of liability and not the other provisions of the ICC statute.
We should be closing, but if there's one more urgent question, I don't see any. So, thank you so much again. Please join me in thanking Payam again.